And joining us now for more is Professor Gad Barzilai, former Dean of Law at the University of Haifa, speaking to us from Haifa. Thank you for joining us, Professor Barzilai. So let me ask you, we heard Yehuda Schaefer, we should note a former prosecutor himself, who's saying it's not that, doesn't that make a substantial difference in the case, in case 4000, or it won't make that to the judges. Do you agree with that? And should it make a difference, at least in that case, which has that most serious charge involved?
So good evening. Just one correction. I was a dean. I'm a former dean. Now to your important question. Well, it's certainly a blunder to the general prosecution. It's not a good day. It's not a day of celebration for the criminal prosecution. Notwithstanding, there is a stipulation in Israel Penal Code, which we call Stipulation 184, according to which still the prosecution can show that Mr. Netanyahu might have taken a bribery or offered a bribery. Now, obviously, much will depend on the redirect investigation following the cross-examination of Mr. Filber. So on the one hand, it's not a great day for the prosecution. They cannot really show at this stage when and if the meeting took place, the meeting in which allegedly a bribe was offered to Mr. Elovitch. On the other hand, it's not the end of the story, and still the prosecution may show a serious suspicion that a bribe was offered to or offered by Mr. Netanyahu. Yet, I should say, it would be much more challenging now for the prosecution to show bribery, yet they can still show breach of public confidence, which is a criminal offense.
Right. Well, let me ask you about that, because there's been a lot of speculation, including by yourself, about whether Benjamin Netanyahu would take some kind of plea bargain deal here. Does this kind of evidence make that less likely, because maybe he's more likely to beat the case now, or more likely that he might take a plea bargain, or the prosecution might agree to a plea bargain on those lesser charges, like you mentioned, breach of trust, that would allow Netanyahu to continue his political career?
Well, I think that you really ask the $64 million question. I mean, this is the issue. The main issue is not whether a conviction will be achieved, but whether Mr. Netanyahu is now in a better position to get a plea bargaining without admitting a crime, only a felony. And I think that now he is in a better position. However, it's premature to know. We should know much more after the redirect examination, namely after the end of Mr. Filber's testimony. Now, don't forget that there are two other criminal cases, case 2000s and case 1000s. And today, it didn't get a coverage by the media, but in fact, the court allowed to the prosecution to bring 3 more testimonies in order to prove case 1000s. So I would argue that still a plea bargaining, admitting a crime, it's a possibility. But certainly, Mr. Netanyahu is now in a much better position than he was, let us say, a few months ago, with all the obvious political and electoral ramifications.
Right.
Notwithstanding, it's only the beginning of this story.